Something borrowed, something gained, something new, something blue. In our ever-present technological AI society, people seem to forget that there is actually a foundation to law. That foundation is not ChatGPT, it's not Perplexity, it is not anything like that, where you receive fake optimistic cases to conform to whatever nonsensical idea you put in there in a non-lawyerly fashion. What is apparent is that most people have no idea that family law has Florida rules of procedure. Florida family law rules of procedure. Most of you probably had no idea that that exists. And if you did not, and you were playing attorney on TV, then you can imagine your result might not be as wonderful as you would otherwise hope it to be. Nevertheless, here's what I'm going to tell you. The Florida Family Law Rules of Procedure are your guidepost for practically everything. There are rules in there that many practicing attorneys have never heard of and may never encounter. And yet there are other rules which are directly on point, absolutely necessary in your case to your victory, strategically, procedurally, and in almost every other way. There are rules that a good lawyer can use against an opponent. If your lawyer is not familiar with those rules and does not conform to them, you may have a problem in your case. What, therefore, do I recommend? Hiring counsel, without question. For example, I had a podcast episode for our Divorce and Family Law podcast in which I stated that a motion is not a pleading. That means if you file a petition and the other side has filed a motion to dismiss, you can go ahead and change your pleading to defeat the motion to dismiss at any time if you like. You do not need an amendment from the court. You do not need court permission or the other side's permission. You can do that once at any time before a responsive pleading is filed. And yet, ladies and gentlemen, this almost never happens. It is seldom that any of our opponents revise their petition after we've filed a motion to dismiss. And if we have not yet filed an answer and counter petition, i.e. pleadings, then they can do so at any time after having reviewed our motion to dismiss and attempting to cure any of those defects. The fact that so very few people do this informs me that very few people look at the family law rules of procedure, which should tell you everything you need to know about the timing of things, about pleadings, about amendments to pleadings, about motions, about discovery and financial scheduling, about timelines, about the number of days a party has to do X, Y, Z, A, B, C, 1, 2, 3. One of the big takeaways from our podcast episode today is you should hire competent and knowledgeable counsel. When you have a conversation with a lawyer, if everything they say is designed to sell you a service and provides you with absolutely no information, that is probably not the lawyer that you need, and probably not a lawyer that you should consider working with. While we do get hired by clients, which essentially means that we are providing you a service, and we have a duty to represent you with experience and diligence, not everybody that discusses a case with you will speak to you as though you're capable of being informed. One thing that I like doing is teaching. I always have, I always will. I've said it to thousands of people. Teaching is in my bones. It is who I am. It will always be who I am. That is never going to change. And as such, when I speak to people, I like to educate them, because ultimately a lawyer's job is to give advice. Your job is to make the decisions. If there's a way to go left, or a way to go right, or a way to go straight down the center, I will give you the advice. Ultimately, you will make the decision. Hopefully, we are on the same page and the case can continue as is in a functional way, driven toward a successful outcome. But the Florida law rules of procedure for family law are very specific. They have rules on summary judgment, rules on relief from judgment. They have rules on injunctions, remedies, mediation. They have rules on evidence, rules on continuances, some of which our opponents do not follow. And even in one case, I recall a judge granting relief when somebody violated Rule 12.460, which was clear and obvious, and their grant or their request for continuance should have been denied immediately and never granted, as they never bothered to have their client sign it, which is really bizarre because that's essentially law school 101 if you know the first thing about family law and family law rules of procedure. That is exactly what you need to do. Make sure that you always understand the rules that apply to your particular unique situation, so that way you will not be caught in a situation where your action is compromised because of a failure of knowledge.